My name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to briefly discuss the victory of law firm Jenner & Block, LLP versus the Trump administration. On May 23, 2025, the U.S. District Court for the District of Columbia ruled that President Trump's executive order number 14246, titled Addressing Risks from Jenner & Block, LLP, is, quote, unlawful because it violates the First Amendment to the United States Constitution. It is further declared that Executive Order 14246 is therefore null and void. This case largely echoes the Perkins-Coie law firm case that we covered in Episode 9. This law firm appears to have been selected as a target due to the fact that the firm once employed Andrew Weissmann, a former federal prosecutor who once served on special counsel Robert Mueller's team during the first Trump administration. This among other issues that President Trump likely has with the firm. Section 1 of the executive order states in language echoing President Trump, in part, quote, my administration is committed to addressing the significant risks associated with law firms, particularly so-called big law firms that engage in conduct detrimental to critical American interests. Jenner & Block, LLP is yet another law firm that has abandoned the profession's highest ideals, condoned partisan lawfare, and abused its pro bono practice to engage in activities that undermine justice and the interests of the United States. In addition, Jenner was thrilled to rehire the unethical Andrew Weissmann after his time engaging in partisan prosecution as part of Robert Mueller's entirely unjustified investigation. Section 2 of the order states that the Attorney General, the Director of National Intelligence, and other relevant heads of executive departments and agencies shall immediately take steps to suspend any active security clearances held by individuals at Jenner, pending a review of whether such clearances are consistent with the national interest. Section 2 further requires the Office of Management and Budget to identify government property, materials, and facilities access that the firm has and to revoke such access. The executive order carries on with various grievances of President Trump and similar orders for punitive actions against the firm, as his judicially nullified executive order against the firm Perkins-Coie did, which we covered in Episode 9. I'm going to quote some of the language U.S. District Judge John Bates, May 23, 2025 order nullifying the executive order stated, quote, this case arises from one of a series of executive orders targeting law firms that in one way or another did not bow to the current presidential administration's political orthodoxy. Like the others in the series, this order, which takes aim at the global law firm Jenner & Block, makes no bones about why it chose its target. It picked Jenner because the causes Jenner champions, the clients Jenner represents, and a lawyer Jenner once employed. Going after law firms in this way is doubly violative of the Constitution. In citing the U.S. Supreme Court in National Rifle Association versus Vol. 2024, Judge Bates stated, most obviously retaliating against firms for the views embodied in their legal work and thereby seeking to muzzle them going forward violates the First Amendment's central command that government may not use its power of the state to punish or suppress disfavored expression. This order, like the others, seeks to chill legal representation the administration doesn't like, thereby insulating the executive branch from the judicial check fundamental to the separation of powers. It thus violates the Constitution, and the court will enjoin its operation in full. Judge Bates goes on in his memorandum opinion in reference to the executive order. Aside from its vague reference to Jenner's powerful pro bono practice, on this too the order is coy. In context, however, the order refers to Jenner's ongoing challenges to two other executive orders issued by this administration, one on behalf of transgender individuals and the other on behalf of asylum seekers, both of which have resulted in favorable preliminary outcomes for Jenner's clients. In referencing attorney Andrew Weissmann, the judge states, Weissmann, a former federal prosecutor, was a partner at Jenner from 2006 to 2011 and from 2020 to 2021. In the interim, he served the federal government in various capacities, including investigating Russian interference in the 2016 election as a member of the team led by special counsel Robert Mueller. Weissman's participation on the Mueller team, plus his public criticism of President Trump and his authorship of a nonfiction book critical of the president, have drawn the president's ear. And so Jenner's relationship with Weissman is, quote, a concerning indictment of Jenner's values and priorities. The judge goes on about some of the implications of the order. According to undisputed evidence in the record, the order quickly had its intended effect. Department of Justice lawyers instructed a Jenner client not to bring its counsel from Jenner to a meeting with the Department of Justice scheduled for April 3rd. Many other clients contacted Jenner with concerns about Jenner's ability to represent them moving forward. Judge Bates discussed constitutional issues with the order. Quote, in this context, retaliation amounts to something akin to the impermissible scheme of informal censorship that arises when government actors use the threat of invoking legal sanctions and other means of coercion to achieve the suppression of disfavored speech. A firm fearing or laboring under an order like this one feels pressure to avoid arguments and clients the administration disdains in the hope of escaping government-imposed disabilities. The Constitution shields clients from lawyers caught in the struggle to serve two masters. The right to sue and defend in the courts is the right conservative of all other rights and lies at the foundation of orderly government. Executive Order 14246 implicates also the Fifth and Sixth Amendment guarantees of the right to choose counsel without interference by officialdom. So the First, Fifth, and Sixth Amendment speak in unison here, all eyeing skeptically the administration's attempt to stifle any voice Jenner and its clients might wish to raise before the courts in protest. An informed independent judiciary presumes an informed independent bar, so limitations on lawyer speech must be examined with care, as such limitations threaten not only the lawyers and their clients, but also the ability of a co-equal branch of government to function. Official attempts to draw lines around lawyers' advocacy and thereby exclude from litigation those arguments and theories the president finds unacceptable, but which by their nature are within the province of the courts to consider, threaten a deep and irreparable rift in the constitutional order because they seek to insulate the government's acts from judicial inquiry. In short, the order raises constitutional eyebrows many times over. It punishes and seeks to silence speech at the very center of the First Amendment, and it does so via the most egregious form of content discrimination, viewpoint discrimination, all in an unacceptable attempt to insulate the government's laws from judicial inquiry. Executive Order 14246 violates settled First Amendment law, and its operation must be enjoined in full. Keep following Executive Coup for further updates on these matters and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you. For more information, check out our website, www.biazzolaw.com. That's spelled B-I-A-Z-Z-O. Thank you.